Welcome to The Workplace, a podcast by CalChamber. I'm Matthew Roberts, Associate General Counsel for Labor and Employment with the California Chamber of Commerce. Hello, listeners. As you are all no doubt aware through CalChamber's various outreach efforts, this has truly been the summer of the Private Attorneys General Act, or what's more commonly referred to as PAGA. The biggest win employers got this year was a long-needed legislative reform that CalChamber spearheaded that allows employers to take reasonable steps to prevent or mitigate monetary penalties under the law, even after a notice of a claim has been filed. But that turns out to just be the first win for employers, as we recently had two California Supreme Court decisions that provide further relief in disposing of these claims. To discuss these cases, we welcome back CalChamber's General Counsel of Labor and Employment, Bianca Saad. Good to have you back, Bianca.
Thank you, Matt. Happy to be here.
All right, so Bianca, let's dive in quickly about just the general overview of PAGA. Again, we like to refresh everyone's recollection about why this was so important and why it's been such a hot topic for years.
Absolutely. So PAGA allows aggrieved employers to essentially step into the shoes of the Attorney General and seek civil monetary penalties on behalf of themselves and all other similarly aggrieved employees. And this is in addition to the underlying damages for several labor code violations. So, for example, an aggrieved employee could bring an action for meal and rest break violations, seeking damages for those claims, and then also bring a PAGA action seeking the civil penalties on top of those damages. There are two types of penalties, default and non-default. Default penalties are where the underlying law doesn't have its own civil penalty structure, and with non-default penalties, the underlying law does. As you can imagine, the penalties can stack up as they apply per pay period, per aggrieved employee going back years, even for minor violations such as a misprinted address on a wage statement.
So with all this put together, then there's a lot of money on the table, and that really encouraged litigation instead of using it more as a solution of last resort that litigation often is referred to as. And I think we've seen that bear out over the 20 years that the law has been in effect, as we get several PAGA appellate court decisions every year, it feels like. And, this year is no different. So let's dive into the first case. Now, this case, Stone versus Alameda Health System, has, a little bit more of a limited impact for our listeners, but still a big impact nonetheless. So, Bianca, what was the issue at this case?
This case involved a public health system created by law in collaboration with Alameda County and the state legislature. This is important because there's this general rule of thumb that the California Labor Code doesn't apply to public entities unless the statute provides that it does. So employees with the Alameda Health System brought meal and rest break claims, among other labor code violations, along with a PAGA action.
Okay, then. So if the labor code, like, rest and meal breaks and, overtime payment and wage statements and expense reimbursements don't apply generally to public entities unless they expressly provide so, why is this even an issue before the court?
Yeah, so there were two issues. First, was Alameda Health System a public entity for labor code purposes? And then second, the Supreme Court had never definitively ruled on whether you could bring a PAGA action against any public entity. The Supreme Court looked at the authorizing statute for the health system and found ample evidence to suggest that the county and state governments intended to create the health system as a public entity, and therefore it's not covered by underlying labor code provisions unless expressly stated in the law. The California Supreme Court then, using this principle, examined PAGA and determined that the legislature in writing and enacting PAGA provided substantial evidence that it did not apply to public entities. So first, the default penalties expressly didn't apply to public entities. Using this and the absence of any express language providing that PAGA applied its non-default penalties to public entities, the California Supreme Court concluded that no type of PAGA penalties applied to public entities.
And that's a huge win, really, for any entity that may be a public agency. And as you can see here, this is not really what you would think of as a public sector employer, right? It's not the state of California. It's not the county of Alameda. It's this legislatively created public agency of the Alameda Health System. And there's a lot of them out there. So those of you who are public agencies as you're defined by your authorizing statute, this is a huge win for you because this essentially means no PAGA claims will be brought against you, which, avoids the time and expense of defending PAGA claims. Unfortunately for our private entities and many of our members out there, this does not absolve us from coverage. And that is where the bulk of PAGA litigation does occur as it is. Now, this is really well highlighted in how much litigation we see in the second case that we'll talk about today, Turrieta versus Lyft. So what was that issue in this case?
So this actually involved different PAGA actions, all against the same employer, but each of the plaintiffs filed some overlapping claims, which is a common scenario that we see in PAGA litigation. For example, one plaintiff can file a PAGA action for misclassification of workers, unpaid overtime, failure to reimburse business expenses, and failure to provide timely wage statements. Then another plaintiff can file a similar action for the similar time period, essentially bringing a second lawsuit for the same violations. So then the question becomes, if one case settles, what happens to the other overlapping lawsuit?
Yeah, that's really complicated. But I think if you look at this, it's just, especially the bigger the business you are, the more likely you are to see this, is that individuals are going to go find their own attorneys. And those attorneys are going to say, hey, we have wage and hour violations, and that means we can have a PAGA action. So one gets filed, and then a few months later, another employee went to a different attorney who has no idea that the first case was filed and says, oh, I also have the same claims because they worked in the same time period, and that's why they went to an attorney around the same time period and filed the claim again. And so now you have these overlapping claims, essentially many lawsuits for the same one issue. So I did find that this case really highlights like how litigation forward this is. Everyone's just throwing lawsuits left and right because there's no other real way to resolve these PAGA actions. And it can be really costly and time consuming, especially if you think about you have to defend now multiple lawsuits at the same time for the same conduct. So what happened to the settlement then with this case? Because you say, one settled and then the others were still out there. So what happened to the settlement and the other actions, and how did the plaintiffs kind of interact with each other?
Yep. So you had the one plaintiff who settled their PAGA action, and then you have other plaintiffs with overlapping claims who objected to that settlement because this meant those plaintiffs lost out on the benefits of being the PAGA representative, and that includes attorney's fees and costs, of course. The courts at all levels, including the California Supreme Court, were not persuaded, and the California Supreme Court determined that the purpose and the express language of PAGA doesn't allow PAGA plaintiffs to intervene or object to settlement in another PAGA action. And this actually makes sense from a public policy perspective for why PAGA exists in the first place. Aggrieved employees, as I mentioned, are stepping into the shoes of the Attorney General as a proxy of the state. So it creates this absurd scenario where then essentially you would have the state proxies who are purporting to represent the state interests. They're disputing their own settlements and actions. In other words, the state is disagreeing with itself, right, on how to settle the action. So the court really looked at this and found, this undermines the whole purpose of the law and would create an unwieldy set of litigation rules around PAGA.
Yeah, and that's what's kind of funny about this, because just imagine if it was the Attorney General. We're just going to say we are the Attorney General, and we file this lawsuit for meal and rest break claims, right? And then we are the Attorney General again, and we are filing the same claim for the same meal and rest breaks, and then we're disagreeing with ourselves on how to settle the case. Makes absolutely no sense. So this is a big win for employers, who can essentially kind of move off of multiple lawsuits with this one approved settlement. But oftentimes, still getting to that point is fairly costly. You're still litigating. You're still going through the time and expense of preparing your defense, executing your defense, and then still, resolving the matter. So with the new PAGA reform that I mentioned at the outset, I mentioned that there's some really good, encouraging, mitigating things that we can do here that kind of helps us maybe cut off or at least avoid such a damaging litigation scenario. So what are we encouraging, or what are you, Bianca, encouraging employers to do really under this new PAGA reform?
Great question. So, and a very exciting one that I'm happy to talk about. So with the PAGA reform, private employers now have, many new benefits to limit their liability overall, and that includes the ability to significantly reduce their exposure to the potential PAGA penalties. And they can do that by taking what's referred to under the law as all reasonable steps to avoid or correct labor code violations. So the really great thing about this reform is that not only can an employer be completely proactive, meaning they're taking all of these steps prior to ever receiving a notice of violation, violations. But even after they've received a notice of violations, employers still have the ability to take all of these reasonable steps related to the alleged violations in order to limit their penalties. So when we're talking about the reasonable steps, this can include payroll audits and, of course, taking any related corrective action to the findings of those audits, implementation and dissemination of lawful written policies related to labor code issues such as, meal and rest breaks, overtime, timely payment of wages, all of those common wage and hour issues that we see. And then a really big one is supervisor training. So making sure that our supervisors are trained on our lawful policies. And then not only that, but there's accountability for our supervisors so that we are disciplining our supervisors and, again, taking corrective steps if and when we realize that there's been a failure to follow those policies or procedures.
Well, Bianca, this was excellent, and thank you for taking some time to discuss these recent cases with me. As we know, PAGA continues to take an outside share of the court's litigation docket, and these new rulings, along with your practical guidance on the reform, I think continues to help put employers on at least a fairer footing than they were before in helping prevent or defend against these claims in the first place. So thank you again for joining me today, Bianca.
Thank you. Always a pleasure, Matt.
And thank you, listeners, for joining this discussion on the workplace. Please share and subscribe to CalChamber's podcast by visiting calchamber.com.